Philippine Legal Doctrines, Part 2. Doctrine of Condonation. Under the doctrine of condonation, a public official cannot be removed for administrative misconduct committed during a prior term, since his re-election to office operates as a condonation of the officer's previous misconduct to the extent of cutting off the right to remove him therefore. The foregoing rule, however, finds no application to criminal cases pending against petitioner. Doctrine of Constitutional Supremacy. Under the doctrine of constitutional supremacy, if a law or contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch, or entered into by private persons for private purposes, is null and void and without any force and effect. Thus, since the Constitution is the fundamental, paramount, and supreme law of the nation, it is deemed written in every statute and contract. Doctrine of Constructive Trust. Under the doctrine of constructive trust, one who acquires land or other property by fraud, misrepresentation, imposition, or concealment, or under any such other circumstances as to render it inequitable for him to retain the property, is in equity to be regarded as a trustee ex maleficio, therefore of a person who suffers by reason of the fraud or other wrong, and is equitably entitled to the property, even though such beneficiary may never have any legal estate therein. Doctrine of Continuity of Jurisdiction. The general principle that once a court has acquired jurisdiction, that jurisdiction continues until the court has done all that it can do to exercise that jurisdiction. Doctrine of Corporate Negligence. It is the judicial answer to the problem of allocating hospitals' liability for the negligent acts of health practitioners, absent facts to support the application of respondeat superior or apparent authority. Its formulation proceeds from the judiciary's acknowledgement that in these modern times, the duty of providing quality medical service is no longer the sole prerogative and responsibility of the physician. The modern hospitals have changed structure. Hospitals now tend to organize a highly professional medical staff whose competence and performance need to be monitored by the hospitals commensurate with that of their inherent responsibility to provide quality medical care. Doctrine of Corporate Responsibility. It is a doctrine following which it was held that a hospital has a duty to see that it meets the standards of responsibilities for the care of patients. Such duty includes the proper supervision of the members of its medical staff. Doctrine of Deference and Non-Disturbance on Appeal. Doctrine of Deference and Non-Disturbance of Appeal. Court on appeal would not disturb the findings of the trial court on the credibility of witnesses in view of the latter's advantage of observing at first hand their demeanor in giving their testimony. Doctrine of Discovered Peril. Under the doctrine of discovered peril, where both parties are negligent, but the negligent act of one is appreciably later in time than that of the other, or when it is impossible to determine whose fault or negligence should be attributed to the accident, the one who had the last clear opportunity to avoid the impending harm and failed to do so is chargeable with the consequences thereof. Doctrine of Disregarding the Distinct Personality of the Corporation. Under the doctrine of disregarding the distinct personality of the corporation, when the notion of legal entity is used to defeat public convenience, justify wrong, protect fraud, or defend crime, the law will regard the corporation as an association of persons, or in the case of two corporations, merge them into one, the one being merely regarded as part or instrumentality of the other. The same is true when a corporation is a dummy and serves no business purpose and is intended only as a blind or an alter ego or business conduit for the sole benefit of the stockholders. Doctrine of Effective Occupation. The doctrine of effective occupation is a doctrine in international law which holds that in order for a nation to occupy a coastal possession, it also had to prove that it controlled sufficient authority there to protect existing rights such as freedom of trade and transit. Doctrine of Election of Remedies. The doctrine of election of remedies is developed to prevent a plaintiff from a double recovery for a loss, making the person pursue only one remedy in an action. Although its application is not restricted to any particular cause of action, it is most commonly employed in contract cases involving fraud, which is a misrepresentation of a material fact that is intended to deceive a person who relies on it. Doctrine of Equitable Recoupment. It provides that a claim for refund barred by prescription may be allowed to offset unsettled tax liabilities should be pertinent only to taxes arising from the same transactions on which an overpayment is made and underpayment is due. Doctrine of Equivalence. The doctrine of equivalence states that an infringement also takes place when a device appropriates a prior invention by incorporating its innovative concept and, although with some modification and change, performs substantially the same function in substantially the same way to achieve substantially the same result. Doctrine of Equivalent Tests. The doctrine of equivalent test is a test established to determine infringement which recognizes that minor modifications in a patented invention are sufficient to put the item beyond the scope of literal infringement. Thus, an infringement also occurs when a device appropriates a prior invention by incorporating its innovative concept and, albeit with some modification and change, performs substantially the same function in substantially the same way to achieve substantially the same result. Doctrine of Estoppel by Laches in remedial law. It is an equitable doctrine by which some courts deny relief to a claimant who has unreasonably delayed or has been negligent in asserting a claim. A person invoking laches should assert that an opposing party has slept on his or her rights and that the party is no longer entitled to his or her original claim. Doctrine of Exhaustion of Administrative Remedies. Under the doctrine of exhaustion of administrative remedies, before a party may seek the intervention of the court, he should first avail of the means afforded him by administrative processes. The issues which administrative agencies are authorized to decide should not be summarily taken from them and submitted to a court without first giving such administrative agency the opportunity to dispose of the same after due deliberation. Doctrine of Fair Comment. It is a doctrine in the law of libel, which means that while in general every discreditable imputation publicly made is deemed false, because every man is presumed innocent until his guilt is judicially proved, and every false imputation is directed against a public person in his public capacity, it is not necessarily actionable. In order that such discreditable imputation to a public official may be actionable, it must either be a false allegation of fact or a comment based on false supposition. If the comment is an expression of opinion based on established facts, then it is immaterial that the opinion happens to be mistaken, as long as it might reasonably be inferred from the facts. Doctrine of finality of judgment in remedial law. Under the doctrine of finality of judgment, once a judgment attains finality, it thereby becomes immutable and unalterable. It may no longer be modified in any respect, even if the modification is meant to correct what is perceived to be erroneous conclusion of fact or law, and regardless of whether the modification is attempted to be made by the court rendering it or by the highest court of the land. Just as the losing party has the right to file an appeal within the prescribed period, the winning party also has the correlative right to enjoy the finality of the resolution of his case. The doctrine of finality of judgment is grounded on fundamental considerations of public policy and sound practice, and that, at the risk of occasional errors, the judgments or orders of courts must become final at some definite time fixed by law. Otherwise, there would be no end to litigations, thus setting to naught the main roles of courts of justice, which is to assist in the enforcement of the rule of law and the maintenance of peace and order by settling justiciable controversies with finality.